All right, hello everybody. I'm Jason Priebe. I'm a partner at Seyfarth Shaw here in our Chicago office, so it wasn't too far for me to go. I think we've got some people in the audience who came a lot farther. We're here to talk about global data privacy, particularly GDPR compliance, and I'm joined by Natalia Northrup, who works with me here at Seyfarth. I have been involved with the Sedona Conference Working Group 6 for approximately 10 years. And I've worked alongside Jim Daly, who was actually supposed to be participating in this presentation today, but he couldn't. So we'll soldier on without him. But I think I routinely deal with challenges that clients of Seyfarth Shaw have relating to both routine business transfers of data out of European Union countries and other parts of the world too, as well as more ad hoc transfers of information for things like internal investigation or litigation. So we're going to talk today about something that's got a lot of people excited, and that's GDPR. And these GDPR presentations remind me a little bit about the way e-discovery was, in the wake of Zuba Lake and when the first round of federal rules changes came around. There's a lot of flurry of activity, there's a lot of presentations and a lot of people getting scared. And there are things to legitimately be scared about violating the GDPR. But I'm hoping that we'll both give like a basic introduction of what all the excitement is about, as well as talk at least in some way about some practical solutions, some ways to kind of navigate your way through these waters and where they're going. So we're certainly going to talk about what's new, what's different about GDPR, as opposed to the existing data privacy regulation, or actually directive, and the rules across Europe as they exist today, by the way, that all companies should be following today. And we're going to call out a couple of things that are really interesting that have got a lot of buzz and a lot of excitement lately. And then last but not least, we promised you a roadmap. I'm going to talk through at least some initial practical things to keep in mind in the world of e-discovery, which we all live in, for how to manage e-discovery after May of 2018. So first off, is anybody familiar with European data privacy as it exists right now? I got a smattering of hands in the audience, maybe about 10%. Is there anybody here who has not heard about GDPR or is not familiar with European data privacy at all? Great. So I'm going to actually start a couple of steps forward then. I'm not going to get into some basic fundamental definitions like what is personal data and things like that, but I'll touch on that a little bit. So if anybody was reluctant to raise their hand, you won't be completely lost. 2018 is going to be a big year for compliance with GDPR across Europe, across the European Union. The date that everybody's talking about is May 25th, 2018, and that's actually the date that compliance begins for a fair amount of GDPR. And the landscape is going to change, but it's not a tectonic shift, because a lot of the things that are currently in existence in Europe when it comes to data privacy are kept. There's only, if anything, there's more, things are enhanced. So let's talk about kind of the world as it exists today. The directive, the Data Protection Directive, which exists and covers both the processing and transfer of personal data, so a bit of a pressure. Those general two chapters, if you will, of the book of dealing with protected information are still the same under GDPR. It's just there are more enhancements, there's more centralization of controls, and some would say there's actually more certainty about what companies or organizations need to do to stay in compliance. However, the thing that certainly got all the attention is I can put my laser on. 4% of global net income, which they call it turnover, that's real money. And I would tell you this. In my experience of working under the existing world, under the Data Protection Directive, your typical company, somebody might ask a question like this, is they'll say, all right, we want to do this transfer, we want to do this particular activity, and yeah, you've told me about some of these EU laws that have to do with protecting information and that there's authorities and they investigate and that there's penalties. What's the worst that could happen? Because somebody oftentimes will weigh the risk and look at that and say, well, all right, so we violate the law. What's the worst that can happen? I think the most important message about what's changing about GDPR is that the worst that can happen is a lot worse than it was before. Before, and kind of in the existing world today, there are some countries which we practitioners that were involved in data privacy in Europe knew to be on the lookout for. Some countries were honestly worse than others, more restrictive than others. And I know just from some of the conversations I've had with data protection authorities that some I could just get on the phone and talk about, and others, talk about what we're doing and it'd be fine. But what's changed about GDPR is that the enforcement is going to be universal. It's going to apply much more strictly. And so now it's not going to be a situation where, oh yeah, we can do this in Ireland, but no way could we ever do it in Italy. The goal is to have more uniform enforcement across Europe, which is a good thing, honestly, for European citizens when you look at it this way, is that I, as a German citizen who's maybe working in another part of the European Union, under the concept of what the European Union law is supposed to be, is that I should expect to have equal protection and rights and not have a situation where the law might be enforced more aggressively in one country as opposed to another. So going back to what I said before, that's actually could be viewed as a positive for an American company or organization, because you know what you're going to get. And you don't have the situations like we do now where somebody says, well, in Spain, they said that they're actually trying to fund their data privacy authority's office on fines. So that's a real bad place. But in other countries, yeah, they're a little bit better. So this, at least, the rules about fines, and also there's a little bit more information in the GDPR about how fines can be levied and kind of the factors that go into play, which will also add more certainty towards compliance. Again, on a positive note. There are plenty of presentations about GDPR where people are scaring the heck out of people with this. Now, I should also mention that's not here, but just to take a little bit deeper dive, there are actually 2 levels of fines in the GDPR. The first is only a 3%, so it's not that much difference. But the important thing to note is that there are different fines for different activities or failures, if you will. And the 3%, which is not that much better, that applies for companies who are unable to prove their compliance and who lack kind of certain principles of accountability under GDPR. And I have described this in shorthand that if you don't have your paperwork together, you could be facing a fine under GDPR. Under the existing directive in Europe, it's more violation driven, and you don't have to worry about affirmative investigations, and if you don't have your process in order and your everything, it's more directed towards harm under the existing way of things. But I think in 2018 we're going to be talking a lot about companies who are in a mad scramble, and I'm going to talk about this later, to make sure you're documenting what you're doing. It's almost like, yes, you have to be in compliance, but you have to show that you're in compliance, which can be, it's nothing that's a foreign concept to people who work in corporate compliance and who are dealing with things like audits. But I think some of those things that we talk about when we talk about corporate compliance, like ISO standards, will certainly come into play when we're talking about GDPR. So it's a handy chart, which is unfortunately difficult to read on the top, but the first column on the left is the existing directive, and the one on the far right is the world under GDPR. And this is helpful, I think, to highlight a couple of the things that are changing. So first, with respect to authority and the enforcement I've already talked about. The second kind of row there is also important to note, and that is, it used to be, or it is now until next year, there's a lot of companies, when they're putting together contracts or when they're involved in data processing activities, I'm frequently asking, all right, who's the controller? I want to make sure I define who the controller is. And the reason I care about that under the directive is because that's where liability rests. And there's a lot more liability for controllers. Yes, there's secondary liability, but it's a lot. Under the directive, it's all about the controllers. GDPR is much more friendly to the European data subjects, and that essentially it spreads the liability around, if you will. So suddenly there's data controllers, processors, and even sub-processors that are in play. And so at least when you're thinking about contractual relationships in the future, it's something to keep in mind. I've talked about sanctions, which is the third row across. There's a couple of other things we're going to be talking about in more detail later. The concept of a data protection officer, which is now something I would say is a good idea, and then under GDPR is something that is going to be required for certain companies depending on their activity. Personal data is essentially the same in concept. It has been expanded to include geolocation information. There was some question about whether that would come into play, as well as online identifiers. This has got a lot of people in the website business a little concerned. Genetic data is not a surprise. So, there's a new other concept we're going to talk about too that's sort of new called the Data Privacy Impact Assessment, which people abbreviate PIA, which means something else to me, but I suppose it could be the same. A privacy impact assessment can be a pain, but again, it's a new concept that's not going to apply to everybody, but if you have to do it, you have to do it right. Why? Because what I talked about earlier, this principle of accountability, you've got to have your information in order to demonstrate, to show you're in compliance. One other thing on the bottom of the screen that's gotten a lot of people's attention is the data breach notification, and it ought to. It's very scary to imagine a 72-hour time period under which notification has to be made for data breach, okay? That, in my conversation with people that were involved in putting that in place in GDPR, I was told that 72 hours was the gold standard, air quote, about notification. So that's why it's put in, because they wanted the gold standard. So be it. And now my colleague Natalia Northrup, I think, is going to talk about all the requirements. Here you are.
Thank you, Jason. So as you begin thinking about GDPR and compliance, May 25th of next year is coming up, and a lot of companies right now and our clients are worried about what is it that you do, practically speaking, to get prepared, because May 25th comes and those fines can start rolling. So you just have a few short months to get ready for this. And I think a good starting point is to look at what is it that you're doing right now, because a lot of our clients already have something in place. You already have to comply with a lot of data privacy requirements, be it here in the United States, or already in Europe. If you're complying with the directive, you're already kind of a long way toward this compliance with the GDPR. However, you need to really take a good look at all 99 articles in the GDPR and think about what are the new requirements and how does it apply to me. So if you're collecting data from your customers, if you're collecting, of course, data from your employees, you have to think about what kind of data you're collecting. You have to put a privacy policy in place that needs to comply with the GDPR. And a lot of clients at the same time, our clients are also doing compliance with the Privacy Shield because that's, as you know, replaced the Safe Harbor. So there's a privacy policy requirement for the Privacy Shield, and there is a separate privacy policy requirements for the GDPR. And there's a lot of overlay, so if you're doing one, you're already kind of helping the other. But you have to make sure that you are fully complying with the GDPR and that your privacy policy is updated. And I cannot even begin to tell you how many times you go on a website with some major company doing business internationally, making millions of dollars. You click on the privacy policy, and it says today that they're complying with Safe Harbor. It's been 2 years, no Safe Harbor. You really need to think about this because it's just a few short months left, and the GDPR privacy policy needs to be up on the website. You have to think about what you're collecting, what kind of data you're collecting, and what is the purpose for that collection, because there's a lot of purpose limitation, and that's very serious now. It used to be on the directive as well, but it is very important that when you're collecting data for a certain purpose that you are not repurposing it without notifying people, getting you consent, and doing all that. Consent right now, so it used to be where you could satisfy this requirement by demonstrating it in a variety of ways. That really, you were supposed to get a consent from individual before collecting their personal data, but there were different ways of getting it. Right now, the only consent that we'll do is express, so better get it in writing, and better file it and keep it. Because if somebody goes and complains to the data protection authority that you're processing their data without their consent, that's a fine. So every consent needs to be documented. You have to think about your privacy program management. Hopefully, most companies already have that in place just for the current purposes that you need to be doing that. But think about what that management program is doing right now and what gap areas need to be filled to comply with GDPR. And then the security in the context of privacy. So there are some specific security requirements under the GDPR where you actually are given some suggestions, which is new. The directive did not include suggestions for security, but the GDPR has some specific things that you would be doing in terms of security of data. Data breach readiness and response, this is something that Jason touched upon, and we will talk about it a little bit later as well. But data breach, it's a brand new requirement. You were never before required in Europe to report a data breach. This is brand new, and it has a lot of our clients worried because the 72-hour requirement is very scary. And putting the whole machine in place of you are aware of the breach, and then you have to notify authorities, you have to notify affected individuals, and suddenly all of this comes into place, and you don't know whose role is to do what in the company, that could be scary. And of course, the GDPR now has all sorts of new individual rights and remedies that people now can go and ask you to erase their data and forget about them, move their data to another provider if you're a provider, and do a lot of other things that are completely new. And in the next few months, you really need to think about how you're going to satisfy all of these requirements. So privacy impact assessment, it's something also Jason touched upon. It says here PIA, it's really actually called DPIA, and it's a little bit different than the PIA that we're all used to. There is a, I don't know how many of you are familiar with Working Group 29. It's the group that was put together to basically implement the current directive, and it consists of the data protection authorities from different member states. And they issue guidelines and different advisory papers on this. So they do have a paper on the DPIA and what goes into it. Not every company needs to do this. Only if you process data that has a high risk of potential risk to the freedoms and rights of individuals. So The extreme example of it would be we have a lot of clients in the pharmaceutical industry. So if you're a pharma company, you operate in every EU member state, you conduct trials throughout Europe, the data you're processing will represent high risk to the freedoms and rights of individuals should it be accessed in an unauthorized manner. So if you do have that, you have to conduct this privacy impact assessment. It will really help you because it will highlight all the deficiencies that are existing in the current system, and it will tell you what needs attention and what needs to be fixed before the GDPR takes effect. So I'm sure many of you are familiar with this, but one part of this DPIA is creating the data flow map and just understanding what is that process? How are you getting this data? How are you processing it? Where are you storing it? For what purpose you're keeping it? Where are you keeping it? Are you transferring it? Is it going overseas? Under what kind of a mechanism is it going overseas? Do you have the privacy shield in place? Do you have any kind of binding corporate rules in place? What are you doing with that data? And what happens when the purpose limitation has expired? So if you are collecting data for a contract with an individual and that contract lasts for 2 years, year 3 comes, you still have that data. Are you supposed to have it, or has the purpose expired and you're supposed to really expunge it? So all of these things really come to light once you start putting together this data flow maps. It's a good exercise. Identify main establishments. So a lot of complaints were coming from the directive because, as you know, every European member state has its own data protection authority, and every data protection authority does its own thing. And the directive was really not a law. It was just a directive that told member states to go create their own laws that kind of satisfy the directive, but they need to do their own thing. The GDPR is actually a law, so now everyone has to comply with it. And the goal for the GDPR was to create a single standard throughout Europe. Now, they haven't really achieved it quite. There are still some areas like they can't decide who children are. In some states, you can say 13. In other states, it will be 16 as to when you need consent of the guardian or parent to collect data. But this is one thing that is supposed to be good for the business because here you are no longer, let's go back to our example of the pharmaceutical company. Let's say you operate in every member state. It used to be that you needed to go to the data protection authority in every member state and make sure you're complying with what they tell you to do. And if anything happens, you need to go to them. And you can imagine if you're a big company, how much advice you're getting from all of these data protection authorities and how many authorities you have above you, and sometimes the advice was conflicting. This is supposed to solve this. Right now, the GDPR says that you identify, it's a one-stop shop. So you identify where your main establishment is. And so if you are operating in 20 countries and your main establishment is in England, that's where the decisions are made, that's where your controlling center is, that is your main data protection authority. So that's who you need to listen to, go for advice to, and that's who is going to be enforcing the GDPR with respect to you. Now, there's going to be a system where the data protection authorities among member states will be conferring with each other because sometimes the issue will spill over the borders, and so they cannot make that decision by themselves, so they will go consult somebody else, but they will be doing that on their level, and then the decision will be handed down to you. So that's supposed to simplify things. Budget and resources, this is painful. So a lot of our clients know that the GDPR is coming, it's going to be expensive, fines are huge. Nobody is still really truly wrapping their head around it. What's 4%, 20 million euros? Sounds like a lot. Is it really going to be happening? Can't I still get away with it? So this is really not the time to cut corners. It's important to get that buy-in from the top management. It's important to get that budget because all of these things, the data protection, privacy assessment, all of these map of the data and all of that stuff that needs to happen now to get ready for the GDPR, it'll cost money. You need resources, internal, external, you need lawyers, you need to make sure you're prepared, and a lot of clients are not prepared to be prepared. So it's important to allocate resources and finances. And I think Jason will now talk about the rights for individuals.
We'll see what we see. I think I do want to talk a little bit about the kind of the new supervisory authorities, though, real quick before I start talking about the individual rights that are of interest. The supervisory authorities are kind of the new data protection authorities. And some things, if anything, their powers have are going to get more centralized and stronger under GDPR. They are still just a website click or a phone call away for any European data subject. And I think it's important to realize that that's not going to change. So if an employee has a grudge, if a customer has a grudge, or even if an individual outsider, maybe a public interest group, has a need to, they can start an investigation against the organization and really trigger an audit of all that documentation and everything we just talked about. So it's, I think a conversation about, well, whether can this happen here? Do we have to worry about this? I think that's certainly part of the conversation, is to think about that. I have been involved in small litigation that spun off a satellite data privacy compliance investigation because someone was disgruntled and unhappy, or maybe they were trying to use one of these requests for personal information as a way to have a side route to find out what information a company had about them in the course of the litigation. So litigants think creatively, and lawyers think creatively. We're paid to think creatively. So those sorts of things, I think, will come in the future. And the supervisory authorities, yes, there's centralized, that we've got the one-stop shop when it comes to enforcement or telling you what you need to do. It's still an open question whether it's a one-stop shop when it comes to fines. Some people, including myself, think that it's not a one-stop shop. So in other words, it stands to reason that if a company has a data breach and it impacts people both in Italy and in Ireland, that company would be fined twice. So one-stop shop for regulations, but unsettled question about fines. Some of the rights of the individuals I wanted to emphasize, let me talk about it over here. The right to be informed. This is honestly, it's not new, but it's certainly, like many other things, it's amped up more, and companies need to have mechanisms in place to respond to requests for information about data subjects, about what information you're taking from me, what you're doing with it, and where it's going, fundamentally. These are, again, things that need to be thought about now, before May of 2018, because the documentation and the infrastructure needs to be in place to handle those. So when a request comes in, who could it be from? Well, any data subject. So who is that? Well, that's anybody under the jurisdiction of the European Union. So customers, yes. Employees, yes. People dropping by the website to maybe fill in something about a catalog, yes. So what are the mechanisms that those people could use? And what do we do with that? What do we do with the questions? How do we figure out a process to make sure that we respond to them? Who's going to look at that? Who's going to write the responses? How do we document that we responded to the question? And these are all things that need to be in place, because remember, I keep hearkening back to accountability. You're going to be accountable for showing that you have mechanisms in place to be in compliance. The other things I want to talk about quickly are rights of access. That's in essence that a data subject has a right to know what you have. There's also certainly a right to correct any mistakes. The right to erasure or right to be forgotten has gotten a lot of talk. We're going to talk about that some more later. But there's interesting things that a data subject can do in terms of stopping what many companies would think is kind of their right to do with the data that they have. So if I want to process people's data, or if I want to keep it in a mailing list, or if I want to use some kind of automated decision making, what are we talking about? AI, if I want to use something to figure out what kind of laundry detergent people in Germany want to buy, I have to have mechanisms in place so that if somebody says, you know what, count me out of that, we have to do that. And we have to know what we're doing. So that goes back to really knowing what you're doing with information and how it works, because all these things have to be built in, and then it's almost like a machine that you need to be able to come in and take a part out or interrupt something if it impacts the rights of one particular data subject. And yes, under GDPR, as I mentioned, there is, everybody talks about fines and enforcements. There's still a right to private legal action too. Data subjects can sue you, supervisory authorities can sue you, even public interest groups on behalf of data subjects who maybe don't have a problem with you, they can sue on the behalf of the data subjects to enforce their rights, even if they don't have what a traditional notion in the United States would be standing or personalized harm, just in the interest of the public. So it's going to be a brave new world in terms of just enforcement and litigation, I think. And I think that there's a lot of companies that are involved in a lot of activity that don't want to be the first to grab the headlines about that. The right of data portability, we're going to talk about it more, but in essence it just means that you need to make whatever information you have about someone available so that they can carry it from one company or one processor to another. The right to objective processing I've already talked about. So the right to be informed. In essence, this can all be boiled down to knowing what you're doing with every scrap or bit of personal data that you have that's identified back to an individual. All right, well, let's bring it home. We're at a conference here. There's lots of e-discovery providers here, all right, who are processing data, maybe on occasion, for European citizens. It's time to start thinking about compliance, not just checking a box. It's time to start thinking about all the mechanisms to track that employee or that European Union citizen data and to tie it back to individuals, because the day will come where somebody is going to pull the red cord and say, wait a minute, I changed my mind. I don't want company X working with my data for this internal investigation, and I heard something about it being transferred to the United States or something. So what do we do? And as an e-discovery provider, if I were working at one, I would be thinking very long and hard about that, because, as I mentioned, there's a lot to build here. And you've got to have those mechanisms in place. And so the what if question needs to be circulated today. And it probably is going to start with, well, we don't even know. We don't even know. Yeah, who are these? There might be some Europeans in here. We never asked. So some of these things just need to be built in, and the time has come to start thinking about it. Because right here, I mean, data subjects, yes, there are all these requirements about consent. It has to be informed. It has to be explicit. And consent is certainly beefed up, but it's still true today, and as it will be true next year, that consent is revocable at any time. So what do you do in that situation? Because it could happen. Right to be informed. These are the questions I think that would be helpful to think about when you're thinking about responding to these requests by a data subject or a supervisory authority who comes in and says, all right, we're here, we'd like you to tell us what you're doing. Maybe they've had a complaint, maybe they don't. They have a right to independently audit if they like. So when is the data provided by that data subject? How are you obtaining it? And what are you doing with it? And then also, if you're sending it onward to someone else, to other companies, if you're exporting it, you need to know all these things, and you need to be prepared to talk about them. There's certain other principles. Data minimization is one, which is, it's really almost common sense to think about that a company should be working with the least amount of information, of personal information, that they need to do whatever the job is as possible. And if you don't need it, get rid of it. And in fact, if you don't need the identification information, if you don't need the names, you should have a process in place to pseudonymize the data, that is to remove the names or the other information, and that makes it much less of a problem when you're talking about passing it around or even exporting it. Not perfect, and there are still restrictions on just having it or processing it in the first place. And I think most of you said you were familiar with the directive, at least. So basically, in a nutshell, processing, that is doing anything with personal information, can only be done for certain legitimate purposes. And then even after that's done, transfer is another entire conversation. That has to be legitimized also. So it's not like you can say, well, I have a legitimate reason to process it, and that means I can transfer it out of Europe. No. Each one has to be independently justified. Okay. The right to be forgotten, is this still mine? All right. Onward. So the right to be forgotten is, in essence, is that and this has gotten a lot of press because a lot of people are frightened about it because they think about, how would I possibly? And you can imagine a company like Google or the New York Times who gets a request. But there are exceptions, by the way, which when I apply to certain providers like that. Right here, it's not an absolute right. However, would it apply to Equifax? Yes, I think it would. Okay, so would it apply to Amazon? Yes, likewise. When that information is no longer necessary to carry out whatever it was that your legitimate purpose was for having the data in the first place. So my Amazon example, I needed to get Nigel's name and address in Europe to send him the book that he ordered, all right? But I want to keep it because I want to market to him later about other books he might be interested in. No, that's beyond the purpose that you needed it for, just to do that in the first place, and you can't go further than that without additional either consent or legitimate purposes under GDPR. And certainly, if he says, thank you very much for the book, now please remove all reference of me from your systems, you have to have mechanisms in place to do that. And you can't say, well, what about the marketing system? What about our data warehouse? And what about the backup? It has to be gone, okay? So again, planning is important when you're thinking about the right to be forgotten. And these are all concepts that are out there, but when people are sitting in meetings in IT departments, there's a lot of chatter about, well, how could this practically work? So there's a lot to be figured out. So down here are these exceptions, which would apply to my New York Times example, by the way. But other things like some public safety, like adverse drug effects or potentially other things might apply to that, but it's not going to apply to a vacation rental company. It's not going to apply to, most companies who have employees or customers in Europe. Would it apply to employee? I've had clients ask me, well, how can we pay our employees if they have a right to be forgotten? Well, of course, while they're still your employees, you need to keep their information, and you need to keep it for some period of time afterwards to make sure that you're in compliance with European, labor laws. But do you need to keep it forever? No. Record retention is always a good idea in the US or other countries, and it's something to always be thinking about. So keep it as long as you're legally required to, and no longer. All right, so again, this is these are some points to think about the mechanisms of how erasure will work and how you will document your compliance. And I'm not going to read them to you, but I will pass over them.
So one of the new rights that the GDPR has put in place is the right to data portability. And this is really done to help individuals transfer their data from a service provider to a service provider. So think about it as you are with a cable company, you decide to leave them, you do not want them to remember you. So as a cable company, you think, I'd rather be forgetting them and erasing them. That would be easier, but this is this additional right, and they can just come and select this data portability right. And that means that they've now asked you to bundle up their data and either provide it to them or send it to the competing cable company. So I don't know, frankly, what would be more difficult, whether it's finding every copy of personal data for that person and erasing it, or actually complying with this. This is probably going to be not easy to do. It will apply to personal data that is provided to the controller. And it will be also applying to anything that's being processed based on individuals' consent. So that is the example that I used. So you have a customer, they've consented to you to collect that data, you're processing it happily. One day you get this request and it says, and now I want you to give it all back to me. It will only apply to when processing is being carried by automatic means. So that means whatever scraps of paper you have, whatever is on paper, you do not need to bundle up, send anywhere. That is absolutely excluded from this. Probably not a big consolation there. It will also only apply, helpfully, to what the subject actually gave you. So if they are on your website and they're filling out information and they put in their address and I don't know, phone number, name, age, so that information they gave you. And then you also the information that you've collected just by observing how they're behaving on your website. So if you're Amazon, it will be personal information that the person gave you and plus whatever they searched on your website. So like in terms of Amazon, I can't even imagine how to comply with this because whatever browsing history you're keeping for your own internal uses, now that all needs to be bundled or sent off. What you don't need to turn over is the inferred data. So whatever analytics you're running in the back room, deciding what that person is likely to buy in the future based on their browsing history, based on what they've purchased before, that is yours to keep. But these other things, the data that's actually provided by the data subject needs to be turned over. And how to comply, there are certain rules in the GDPR on how to do it. You cannot just choose how to comply with it. You have to do it in a structured, commonly used and machine-readable form. So it needs to be something that they can use easily. Controllers should also allow for direct transmission to another controller if technically feasible. Now, I'm sure there'll be a lot of fighting over what's technically feasible, but I think in the context of providers, many providers, it'll be technically feasible for you to turn it over to your competitor. Retention. Some of our clients are worried and they're saying, well, what does it mean? If I have to bundle up this data and move it forward, do I have to now keep it any longer? And the good answer is no. Whatever retention schedule you have currently in place, which should be periodically updated, and you need to make sure that the data, different categories, records, that they're being retained for the period that they need to be retained and no longer. So you're erasing that data as it expires through its life cycle. This does not create any new requirements. So if the data is gone and somebody comes to you and says, and now I want to exercise my right of data portability, you can say, here's my retention schedule. Your data was erased pursuant to the schedule. I no longer have it, and you're off the hook. Timing. This is a little worrisome. So you have to once you receive that request, you have to respond to it without undue delay. But just to make sure that there's no fighting over what undue delay is, they put the outer limit to it and said 1 month. Now, if you're a big company and you're receiving dozens or hundreds of these a month, that could be difficult. So that's where that budget, resources, and buy-in comes in, because you have to have a team in place. You cannot just say, and now, dear IT employee, you are going to also be responding to this. This is a full-time job if you're a big company. So if you have a complex case, I'm envisioning Amazon here, you can take up to 3 months. But within the first month of receiving that request, you have to tell the person asking you for the right to their data portability that you are going to take these 3 months because it's a complex case. So you have to communicate with them somehow. And you have to have that communication plan in place, and you have to have people assigned to it and figure out how you're going to do it. Every request that comes in will need to be documented because that's how you show compliance. And that team needs to also document their steps as to what is it that they've done, where did they go to look for that data, how they transferred it, where it went. And the security requirement is also a little bit scary because you have to ensure that when you're transferring that data, that it's getting into the right hands. So the requirements in the GDPR is that you have to require for some sort of authentication, that you need to make sure that it's actually getting to the person who is asking for it or to the designated provider. It's including encryption. Encryption is expensive, as you all know, and so this is painful. For a lot of companies, this is going to be a lot of money that's going to be spent on this, and it will be difficult to comply with. Privacy by design and by default. A lot of people are talking about it as well, but go ahead, Jason. I know it's yours.
Natalia is more than capable of talking about privacy by design and privacy by default, but actually I'm going to go step it up a little bit because I want to get to the roadmap, which is why we're all here. I saved that to the end so no one would leave, so I can talk about it. But privacy by design and privacy by default is what I've talked about earlier, and that is really building into what you have privacy mechanisms. So it's like the old commercial for Prego spaghetti sauce. It's in there. You just have to bake it into what you do and when you live and breathe. So when people touch personal data for those EU citizens, from cradle to grave, if you will, we're going to be thinking about data privacy, and we're going to be thinking about controlling what we have and how long we have it and what we do with it. That goes towards the purpose for what you got it for in the first place, and making sure that you limit or control that. And if you're thinking about doing anything more with it, you really better think twice, because you got to, and this is almost like the list of no list of things, at least points to think about when you've got that personal data. Can you do it? Should you have a touch point where you actually consider, well, hold on, I don't know, I'm not an expert, but I think there might be some data here from European nationals. I think we're supposed to do something. Even that, somebody should have that conversation, is really someplace that every company needs to be. So what am I talking about? I'm talking about internal processes. I'm talking about training. I'm talking about the same kind of employee training that you probably all think about doing for data privacy, data security. This is for privacy compliance. And maybe some people might be surprised to find out that some United States here actually have a requirement for like data privacy training and implementation and a response plan in the event of a data breach, like Massachusetts and other places. So some people are surprised to hear that there's actually a requirement even for data that doesn't belong to European citizens. But anytime you do any of these things, it's good to at least think about if you're repurposing the data, if you're using it for something else, is this something that we can do under the authority of what we had? And really, the whole concept of privacy by design is something else that is going to need to be documented. You're going to need to demonstrate to those European supervisory authorities when they come knocking that you have this in place. So again, it's a really kind of a fuzzy concept that everybody says, oh yeah, that sounds really good to me. How do we prove that we're doing it? So again, ISO standards, policies, procedures, best practices, these are things that you can document in your organization to have in your toolkit for when the time comes. So how do you do this? I've talked about the privacy impact assessment tool. That's helpful, and that certainly will get you along the lines. Now, privacy impact assessments aren't required, but I think it's a good exercise, even if you don't do the whole thing. Know what you're doing, analyze where the data is going, and this is also another, I think Natalia said something was going to be painful. I think it's painful to start thinking about third-party transfers and those contracts. What protections do you have built in? Where's the data going? And if you have other corporate entities or partners or even straight up outsourced functions in your organization, what do you need to do? What mechanisms do you need to put in place for those? It could take a lot of work. So on to data security.
And we're kind of running out of time, so I'll just very briefly talk about it. We talked about the data breach requirement for some time now, but this is a brand new requirement, not currently a requirement. 72 hours, go figure how to comply with that, but it's upon you becoming aware that somebody's in your system. So that is really a critical time, because when you find out that there is an intruder, as you all know, it takes a lot of investigation and a lot of people involved to try to figure out what is happening, who is in your system, what are they taking, how long have they been there. 72 hours is extremely short to go on the record and go and tell your data protection authority that here's what happened and here's what we think we need to be doing right now. It's a lot, and you have to put it all in writing, and you're going on the record. So this is going to be difficult. The data subjects whose information was taken, they need to be notified without undue delay. Nobody knows what that means. There is no months, year requirement. So I'm sure it will be a case-by-case basis depending on how many people are affected, what kind of data was taken. However, there's this very helpful provision here. It's all unless. And unless becomes really important because if you investigate, you do your due diligence, and you decide that the risks and freedoms of persons will not be at risk here because of this data breach, then you do not need to notify. And so that needs to be documented, and you have to have a really good procedure in place for this and people who know what they're doing. It's very easy to show if you have encryption, same as safe harbor here in the United States. If your data is encrypted, it was taken, the key is not taken with the data, then you can say that there's no risk of harm, and I don't have to notify anybody. So document your investigation, very, very important. If you fail to report the breach and you had to report it, there'll be fines for the breach and for the failure to report. These are just some helpful pointers on what to do. Again, minimize what you're collecting. Don't take more than you need. Once the purpose is gone, erase that data, comply with your records retention schedule. And also important, people now have it in the States. It's kind of a lot of companies have this security incident response team. It'll be really important to train your European employees. They need to have this team in place, and that team needs to practice what to do should a breach happen. The data protection officer. So a lot of our clients think that it's required by everybody, and they're surprised to find out it's not. And not surprisingly, you're required to have it if you're processing a lot of personal data. It's your core activity, and if you have it going on a large scale, and if you're processing special categories of personal data. So a good example, going back to my pharmaceutical company example, you would be required to have a DPO in place because you're collecting a lot of data. It's the core of your activity. That's what you're here for. You're collecting this data from trials, from people who are participating in them, from patients, and all of that is being done regularly and systematically, and it's a lot of data. So then you have to have a DPO. Who is a DPO? It's going to be a person either within your organization. It can be also a third-party service provider. So it can be a law firm, it can be a lawyer, and it's just a person who will be overseeing what is happening with the data and to make sure that the GDPR compliance is actually occurring. That person needs to have access to the highest management level, which is important. It can't be just a nominal figure. We've appointed a DPO, here's this person, and this person has no authority, has never met the CEO, doesn't really have a say, has no power to really accomplish anything. That's not going to cut it, because that person needs to actually have power to implement the GDPR, because as you can imagine, there'll be a lot of resistance to some of these things that need to happen. So in addition to the autonomy, seniority, and influence, the person who is in this role will need to have in-depth knowledge of the GDPR, of the data privacy laws in Europe and in the country where you're operating. And that expertise will need to be commensurate with the complexity, sensitivity, and the amount of data that you're processing. So not surprisingly, if you are a giant company that's present in every member state in Europe and you're processing a lot of personal data of customers, then that person will need to be of a really highly level on the expertise scale. And if you're just a smaller company, then maybe you don't need to have someone for whom it's a full-time job. So actually a person who is, if it's your employee, they can also have another role in your company and take on this additional responsibility. But obviously if you're a big company and this is a big job, then it's better to appoint someone full-time to this. And I think Jason will take us through the roadmap.
We're in the home stretch. So one of the things I wanted to do is talk about some practical things that we can do to deal with what's coming. But first, just to kind of recap, the sky is falling. Yeah, this is bad. There's a lot to be done. And May 2018 is not that far away. So a lot of these really complicated requirements like a DPO and a privacy impact assessment don't apply to all companies. But many of them do, and these fundamental principles apply to companies even if you're just trying to sell stuff in Europe, or even if you've got a satellite office and a small number of employees in Europe. So what I tell people is if you've got employees or if you sell things in the European Union, you need to pay attention to this because this matters. Let alone if you're a massive e-discovery service provider and you're collecting data all over the world and transferring it around. And gone are the days, I think, or soon will be gone, the days where you can say, I just let the clients worry about that. They just tell me they're in compliance. Because remember, GDPR spreads that liability around the table, if you will. It used to be only the data controllers need to be worried about it, but times have changed. Well, right here, processors have increased roles and liability. So, e-discovery provider, that's you. And it's not quite enough just to say, well, we've got a contract that says that, all the responsibility is theirs, because when the enforcement arm comes down in Europe, that contract's not going to get you out of all the trouble of answering all the questions and potentially even the fines. So what do we do? Documentation is really important. Building this machine, which is complicated and has a lot of moving parts, is important. And I think it's important at an organization to go ahead and sit down, to bring the right stakeholders into the conversation, to seat the right people around the table, and to say, all right, this is what we have to do. Let's figure out how it makes sense for our organization. What do we need to do? There's actually 2 different teams of attorneys in Seyfarth-Shaw that handle European data privacy compliance. One, who's my colleague John Tomaszewski works on a lot, and that is routine business transfers, what we need to do to get people paid, to fulfill customer orders, and to do whatever it is the business does on a routine, regular basis. So things like BCRs, things like established vendor relationships and contracts, third-party protections. And then my part, which is I do more ad hoc transfers for, internal investigation, legal compliance, domestic or foreign litigation proceedings, where we got to get the data now, something's going on, and we need to figure out a way to make it work. Those are two different conversations, but they're two different things that companies and organizations need to be thinking about, because you're going to respond to them in different ways, and you need to have different mechanisms under GDPR to handle it. And you got to plan now rather than wait until that investigation hits, because then you're trying to build a car while you're rolling down the road. So what's important? Obviously here, documentation is important. Think about and document what you're doing with that personal information so that you have it, and it's almost like there was a trend for a while where companies would do what do they call it? It's not a statement of the purpose, but it was a mission statement, all right? So think about a mission statement for European Union personal data, all right? We collect personal data from people for this purpose. And maybe it's going to be different for each little mechanisms or what you're doing. So we've got a marketing effort here, or we're trying to introduce a new profit here, or we're doing a trade show there. But you've got to really think about what you're doing with the data, because why? You need to know when you're getting close to going outside that, because that's when you would be committing a violation. So describe what you're doing, why you're doing it, and make sure that that matches up with GDPR. Keeping things for marketing just in case is not compliant with GDPR, okay? Perfectly fine in the United States, but Europe is a different place. And if you're doing processing, put things in place. Again, this is privacy by design, privacy by default, of data minimization, pseudonymization, the things I've talked about earlier, to minimize the risk, and honestly, to do away with a lot of the risk, and also the challenge of if a data subject comes in and says, well, I want to know all the data you have for me, and I want to know what you've done with it, and I want you to tell me very quickly. And then later, I want you to get rid of it all. It's a lot easier if you remove their personally identifiable information from it. Suddenly, it's just a random number, and the risk is much smaller. So safeguards and security measures, again, ISO standards, best practices, internal procedures. I can't speak enough about building those things in place, and that's part of privacy by design, honestly. Identify where that personal data is going. I was in a meeting a couple of months ago, and somebody described this as toxic waste. And they said European data is like toxic waste. We don't want to have it, and there's just a liability, and we got to control it. And maybe that's right. So it's important to think about that if you're handling it that way, and think about, well, where does it go, and is it copied, and is it transferred? And you might be surprised. You might be surprised to find that somebody has a separate data warehouse or something else that they're doing for what they think is a perfectly legitimate business purpose, but it could be a violation of European data privacy law. And so shut it off. Ask yourself the earlier questions. Is this legitimate? Is this something that was a reason or for purpose that somebody gave it to us in the first place? So are we talking about e-discovery providers again? It's an uncomfortable thing to think about, but yes, we could be. Those massive databases, those big relativity databases out there, are there European citizens in there, and what protections are in place to make sure that everybody's rights are being protected? And make sure that you've got data subject notification, consent, that you've dotted the I's and crossed the T's with respect to legitimately having what you have before you get it. Because it's a lot harder, I will tell you, when the data privacy authority or the supervisory authority, which they're about to be called, when they come knocking on the door, then you're in a mad scramble. Oh yeah, let me think about it. Oh yeah, this is the legitimate purpose that we had. And then they're going to say, well, that's great. Do you have any documentation of that? Do you have any documentation that you told the data subject that? it's almost like coming up with the story after something has happened. It may be absolutely accurate and true, but it's a mad scramble to come up with it. You're much better off having it ahead of time. And if you don't, remember, accountability, you've got to be able to demonstrate your compliance even before somebody comes and knocks on the door. Because they could come and knock on the door and just simply ask you to demonstrate your compliance, not because they're investigating anything. And those days are coming. So, and again, all these things here need to be done before you even think about transferring to a country without adequate protections. And by the way, that is the United States. Okay. I think I've got, right, I'm a little over. So, but please feel free to, call, tweet, whatever. Happy to answer any questions anybody has. And thanks for your time.